Good afternoon. Welcome to our Mountain States Legal Foundation webinar. I'm Sean Page. I'm the Communications Director at Mountain States, and I'll be your moderator today. We host these online forums to speak directly to our friends and supporters, to the press and the public, and to talk about our legal cases and the range of related issues we deal with at Mountain States. Mountain States is a nonprofit public interest legal firm established in 1977. We're located just outside Denver, Colorado. We defend our clients pro bono in defense of individual liberties protected by our U.S. Constitution. At Mountain States, we believe freedom is worth fighting for. We'll begin today's webinar with a three-way moderated discussion and then open it up to your questions and comments. You can find a place to submit your questions on the bottom of your page marked Q&A at the bottom of the screen. You don't have to wait for the Q&A section to submit your questions. You could go ahead and do that while the discussion is going on if you know what they are. Joining me today is Mountain States Attorney Cody Wisniewski, who takes lead in our Second Amendment work at the Foundation. Also joining us today is a name many of you probably recognize, David French. David is a journalist, author, and he's a Harvard-educated attorney. He was a longtime writer at National Review. He's also an Iraq War veteran. Thank you for your service, David. And he's a contributing writer at Time magazine. Focus of today's discussion is the Second Amendment, and it comes in the wake of a head-scratching decision by the U.S. Supreme Court to not take up any of the 10 potentially important Second Amendment cases it could have considered this time around. Let's just start it off by setting the stage for what we're going to be talking about today. Before we start talking about the decisions or the non-decisions last week, let's go ahead and discuss how we got to where we are today on the whole Second Amendment issue.
Absolutely, Sean. And David, thank you very much for joining us. We really appreciate it. So for those of you that don't follow Second Amendment law or don't follow the Supreme Court, basically what we have is we've had two kind of landmark Second Amendment decisions coming out of the Supreme Court, and that was Heller in 2008 and McDonald in 2010. And since then, it's been almost complete silence from the Supreme Court, with a minor per curiam opinion coming in 2016. But in January of 2019, the Supreme Court granted certiorari, meaning they agreed to review the first Second Amendment case that they had since McDonald. And this case was the one that we've all kind of heard of, which is New York State Rifle and Pistol Association versus the City of New York. Now, the case was delayed and pushed back, briefing was moved, and New York City amended its regulation. New York State passed a law which kept New York City from returning to its previous regulation. And as a result, the Supreme Court began to discuss mootness, or the question of whether the case was ripe for Supreme Court decision or needed to go down to develop further. And in April of this year, the Supreme Court vacated and remanded that case, sent it back down to the lower court to determine if the petitioners in that case could plead for damages. And if they could plead for damages or could preserve their damages claim, that would allow the case to remain live and they would be able to challenge the New York City regulation. Now, this decision from the Supreme Court was highly criticized by a lot of Second Amendment advocates. Some people thought it was just the court punting on the issue. And I had actually taken the position that it might have been a good thing because there were a number of dissents that were filed and actually a concurrence from Kavanaugh. In the concurrence from Kavanaugh, he said he was concerned and thought that the Supreme Court needed to take up review. Alito authored the dissent, which was joined by both Gorsuch and Thomas, and they all weighed in and said that the court needed to review the subject of the Second Amendment, whether or not it was this case. So my thought was that the court was punting this case because of some procedural concerns, and then instead would turn to a number of Second Amendment cases that were pending before it. And that's kind of what brought us to the situation where what we experienced last week.
Is that a pretty good summary of where we are, David? Do you want to add anything?
Yeah, so I think that from a gun rights perspective, what has occurred is not worst case scenario, because worst case scenario would be losing the New York State case on the merits, but we're getting close to it. And I think in hindsight, what has happened is that the Supreme Court took the easiest possible case that it could take, that had come up to it, which was the New York case, which involved a set of facts that were really pretty remarkable. I mean, if you had a premises permit in New York, your ability to take the weapon that you owned outside of your home was extraordinarily limited. I mean, you could only take it in a certain kind of locked condition to one of a number of gun ranges that were in the city of New York. I mean, the idea that there was any sort of right to bear arms as opposed to keep arms in that circumstance, it was essentially non-existent. And so it was an extremely draconian law. And the only real interesting thing to me about the court taking that case, and I wrote about this back when it took the cases, would they do something interesting like begin to establish what is the proper level of scrutiny that you're going to apply in a Second Amendment case? Are you going to apply a kind of scrutiny at all? Sort of what are the legal tests? Because this is a immature body of case law. As soon as I saw the mooting happen, the old civil liberties lawyer in me knew exactly the game. Seen this a million times in university speech code litigation and other circumstances where the state is kind of caught with a plainly unconstitutional law. Rather than sort of fighting it all the way, they'll either settle or they'll try to moot out the case by changing the law, which is what New York did. But I still had some hope for some cert grants because some of the cases that were pending were pretty egregious. They weren't even some of the harder cases, such as a magazine capacity restriction or an assault weapons ban. They were some of what I would call easy Second Amendment cases, such as New Jersey's restriction on your ability to bear a handgun outside the home based on your ability to show need. If I have to show need to exercise a right to a public official, that's not a right at all. And so I had some high hopes that there would be at least one cert grant because some of the cases were pretty egregious. And so to see a cert denial on a blanket level, not just of the quote unquote harder cases, which I still think shouldn't be all that hard based on the language of Heller that we can get into, but harder cases sort of in a political sense, that they would reject even the easy cases was sobering, to say the least. And so that's where I am. I'm extremely sobered about what has occurred, and I'm sobered about the reasons why it has occurred.
Cody, what do you think about that?
Yeah, I think I completely agree. I mean, New York Rifle presented that really narrow fact question: transportation outside of city limits, really clean. And if the Supreme Court wanted to weigh in on this issue, it gives them a good opportunity. Now, what David's talking about is those 10 pending cases that were waiting before the Supreme Court, and they had held these over as they were considering New York Rifle. And those covered, I mean, I think there were 6 that dealt just with carriage outside the home, with public carry. Warman, which is the Massachusetts case, that's the one that dealt with assault weapons and high capacity magazines, using their words. And obviously that's a tougher question. There was also a case pending coming out of California dealing with California's handgun roster. California believes that all handguns are presumptively unsafe unless California says that it's not unsafe. And it has to go through some testing, and they have to have specific features. Some of those features are not available in the firearms industry, and they never likely won't ever be. Manufacturers are saying that they can't implement. One of those is micro stamping on 2 places on an ejected cartridge. It's just not possible right now. So a case like that follows the Supreme Court's per curiam decision in Caetano a little bit. And in that case, the Supreme Court basically said, under our Heller analysis, stun guns are protected under the Second Amendment as an arm. Just because it's a technological development doesn't mean that it's not a protected firearm. So I could see them having granted in the California case as well, but just an outright denial of 10 pending cases was, so I like the word sobering. I think that's a good phrase.
So, David, any particular cases that you were kind of itching to see them tackle?
Oh, I was absolutely itching to see them tackle the public carry cases. The cases out of New Jersey, Massachusetts, Maryland. these cases, because remember that the Second Amendment has a double provision, the right to keep and the right to bear arms. And Heller, which a lot of us hoped would sort of be read more broadly, that it would be read more broadly in accordance with some of the dicta in the case, really narrowly, the actual holding was reversing a DC regulation or DC law that prevented someone from keeping a handgun in the home for self-defense. So it was squarely in the keeping category. But again, there's two words. There's keep and there's bear. And if bear means anything, it means, I don't know, bear. I mean, these words have a meaning. And as I said earlier, if I have to petition the government and show a need that they subjectively evaluate before I can exercise this right, it's not a right at all. And, you know, and I think other forms of case law and say in the First Amendment context are pretty helpful. If I have to petition to or make a request of a government official to exercise my free speech rights and have to show a sufficient need to exercise those rights, if such a regulation existed, that would be struck down instantaneously. And there's a body of case law striking down with, you know, metronomic regularity all of these various attempts from governments to put prior restraints in the face of speech, where and limiting the government's discretion dramatically in, for example, its ability to deny or permit for a parade, or its ability to put time, place, and manner restrictions on free speech rights. And so I was hopeful. I wasn't expecting Second Amendment jurisprudence to mirror First Amendment jurisprudence, but I was at least expecting the word bear to mean something. And now it's true. It's true. The lawyers who are watching right now are saying a cert denial isn't a ruling on the merits. I got that. I got that. The Supreme Court has not struck the word bear from the Second Amendment. It has not done that. But it has let stand laws that basically have. And that's of real legal consequence. So, you know, what's happening? I just think we don't have a coalition of 4 justices who has confidence that their vision of the law will prevail. And so the 4 progressive justices aren't banding together to grant cert here, and there are not 4 of the 5 Republican appointees that are banding together to grant cert. It's in spite of the fact that, as Cody pointed out, there's 4 justices that seem ready, quite ready, to review these cases, but they're not.
Yeah, and I guess the big question then is why? Why is it politics, or do you have any additional analysis of why they're maybe ducking is too strong a word, but avoiding this topic?
Cody, do you want to give a crack at that?
Sure. I actually wrote a piece that was featured in National Review last week, specifically about this, and I went through kind of since McDonald to today, those 4 justices, what we would call maybe the more conservative justices, have all weighed in on this subject matter generally in some form. Thomas has been dissenting from denials of certiorari and Second Amendment cases for a while. Gorsuch joined a dissent in Peruta, which was a California carriage case, actually. And when he first got on the bench, Kavanaugh wrote a kind of semi-famous dissent in Heller 2, which was a follow-up to the first Heller case when Kavanaugh was on the DC Circuit, challenging the DC Circuit's application of a means-end scrutiny test, and instead laid out the text, history, and tradition test, which a lot of us subscribe to from Heller. And then Alito has been very vocal lately about the Supreme Court's treatment of Second Amendment issues. So there's clearly 4 conservative justices that would grant, or seemingly would grant, certiorari. And you only need 4 to grant, but you need 5 to win on the merits. So to me, that says that they don't know where Chief Justice Roberts stands on this issue, or Chief Justice Roberts has told them that he doesn't want the court to weigh in on this issue. And they're worried enough about where he might come out, where his jurisprudence might lead him, that they're not willing to risk putting a case before him and seeing how he comes out on the issue. And remember, When the Chief Justice is in the majority, he gets to assign the opinion. So if he is in the 5-4 majority, he could assign the opinion to himself and thus, lay out the legal framework. And, while the conservative justices could sign on to the final judgment, but could, dissent as to the reasoning, it would be tough to have this fractured Supreme Court opinion on a Second Amendment issue when it would only be the third authoritative Supreme Court opinion that we have on the matter. So, but the same is true of the progressives, right? I mean, they could have done the same thing. There's 4 of them, they could grant cert, but they must also not be sure where Chief Justice Roberts is. So, in a world where we're all kind of questioning a little bit on both sides where Chief Justice Roberts is going to come out on opinions, I think that's particularly acute in the Second Amendment context.
Just a reminder to our participants, if you want to submit your questions, you don't have to wait to the Q&A. There's a button right down on the lower panel, a Q&A button, and you can go ahead and submit those now. We've covered a lot of the legal technicalities, and you're both great lawyers. What does this mean, though, to the average gun owner in America? For people living out there in states or municipalities that may not know, there may not be certainty in what the rules are. Could you talk a little bit about it from the average gun owner's point of view?
For the everyday gun owner, these cert denials didn't change anything. You're under whatever status quo of your jurisdiction. And what's true now is that it is still true now that the primary source of protection for Second Amendment rights is at the state level. And quite frankly, the gun rights movement has been one of the most successful movements in modern political history when it comes to sweeping through the states to change the law. There is a GIF I published a year or two ago, and it shows graphically all of the states that went from no issue. In other words, you cannot get a carry permit at all, or may issue, which you can with the permission of the government, and shall issue, the balance since from like 1986 to say 2018, 2019. The change is remarkable. I mean, just remarkable. I live in Tennessee, and Tennessee gun laws are so protective of Second Amendment rights that you're practically issued a weapon when you enter the state. But it's the odds are we're going to pass a constitutional carry bill here relatively soon. It's made it out of committee. I'm not sure where it's been in the last couple of days, but this is state level protection. What that means is, the good news is that the outcome of these court cases doesn't do anything to that. If you live in a state that is broadly protective of the Second Amendment and broadly protective of gun rights, you're good. You're good. The bad news is that while the Supreme Court every week, month, year where the Supreme Court goes by without further defining the federal protections, the constitutional protections for the Second Amendment, the greater it is, the more apparent that it is that your gun rights are then vulnerable to federal regulation, which would trump the state regulations. So that's one of the really important projects of Second Amendment litigation, is if everything you win at the Supreme Court level takes that particular doctrine out of Congress's hands. So a future Congress cannot overrule Heller, for example. It can't pass a law that says you can't keep a gun in your own home for self-defense. But the fact that that's basically all that we have in Second Amendment jurisprudence at the Supreme Court level means that there is a theoretical vulnerability, a pretty high theoretical vulnerability to federal regulation.
We're getting some questions now from other participants. Todd asked the question, can the court hear these cases at a later time? That's a good question from a layperson like myself's point of view. I'm like, well, when will we get another shot, a bite at the apple? Does that close it forever? Or can these cases be reconsidered at a later time?
I'll jump on that. So the court can't consider these specific cases at a later time. If cert was denied, it could be the end of the road for them. For the New York rifle case, that was actually remanded. So that one could come back up to the Supreme Court. But these issues are still present, which means similar cases in different jurisdictions could come up, and the Supreme Court could decide to weigh in on the issue then. So the carriage cases that were before the court, the public carry cases, were coming out of New Jersey, Maryland, Massachusetts, and then there was an Illinois one dealing with an out-of-state person getting an Illinois carry license. So those states have an authoritative decision from their circuit because the Supreme Court denied certiorari. But cases could come up from other states, could come up from other districts, that could raise very similar issues. So it's certainly not the end of the road for federal vindication of your Second Amendment protected rights. But I think what this tells us more so than anything is twofold, exactly what David was talking about. First, a lot of this protection of your rights is going to come from the state or local level. And that's always been, one, important, but two, kind of the founders and framers' dream, right? Is that the states would have the power to protect these rights or to regulate what they needed to regulate on a more local level. I think the other thing is that this tells us that the circuit courts are going to be much more important for the Second Amendment movement right now. There's some theories in public interest litigation. Sometimes people call it losing your way up. So you'll go to the worst possible district court in the worst circuit, get the worst ruling you can get, and then the Supreme Court grants cert because it has no other choice. Well, I don't think that's a viable strategy anymore. Not that was ever the strategy that Mountain States would use, but I don't think that's a viable strategy for public interest litigation in the Second Amendment context. I think people need to reevaluate the circuits a lot more. Josh Blackman actually had a really interesting point on this of maybe the way that the Supreme Court weighs in is a Fifth Circuit opinion that extends the right so far that the Supreme Court wants to weigh in. I really hope that that's not the case, but it is an interesting take. So I think focusing on that state and local level, as well as focusing on those federal circuit courts, kind of will be how the movement progresses right now. Outside, at least in the litigation context. Obviously, in the legislatures and the state legislatures, David's absolutely right. I mean, there's been a huge movement to protect gun rights. Constitutional carry, which allows you to just carry concealed pursuant to the state constitution, wasn't a topic of discussion 20 years ago. And now it's been instituted in a number of states. So there is definitely progress. And I don't think people should be completely discouraged, but I don't think we should rely on getting an authoritative Supreme Court opinion until at least something changes with the court.
Isn't there any danger of a federal circuit doing damage to state laws that we are like or find favorable?
As a general matter, what's happening is gun rights activists are challenging overly restrictive state laws. You're not seeing much litigation from gun rights opponents challenging more permissive state laws. There's not really a legal theory, much of a practical legal theory for that. One thing I'd point out, I think that I totally agree with something that Cody said. There used to be, for years and years and years, one of our goals in multiple other areas of civil liberties litigation was, the way I put it is, if you win every case, that's good news. If you win some and lose some, that's great news, because that means you've created the circuit split. You're going to get to the Supreme Court and you're going to settle it. You're going to get that. You're going to know one way or the other. You're going to get that final decisive opinion in whatever issue area you're talking about. But with the Supreme Court so reluctant, obviously reluctant to take these cases, we have to look at it as this is just going to be a slog. It's just going to continue to be a slog. And there's some people who say, well, the Supreme Court hasn't weighed in because they're waiting for these issues to mature. There's sort of this line of reasoning that says, well, the Supreme Court doesn't want to weigh in too quickly. It just want to see how these issues ripen, how they mature. Well, y'all, these issues are mature. They're shaving. Their voices changed. I mean, this is an area of case law that is very ripe for the Supreme Court to weigh in, which is why it was distressing to see what the court did. I was actually more distressed in some ways by what the court did on the Second Amendment and qualified immunity, but that's a whole other issue, than I was by its actual opinion in the Title VII case, because it just indicated a real unwillingness to grapple even with, as I said earlier, the easiest of cases. And so that's why I keep saying sobering.
Another question from a participant online, and this is a political question. What do you think would change, and what could change depending on what happens this fall at the presidential level and in the congressional races? How can that impact gun owners?
I mean, for the makeup of the court, I think that's what'll most likely change coming from the presidential election. It seems likely that within the next 4 years, there's got to be a vacancy on the Supreme Court. I don't know, whether that's Justice Ginsburg has been, talked about. She's been on the court for a while. Justice Thomas has been on the court for a while too. They're both getting older, so there could be a vacancy on the court. There's also the possibility of, which way is Roberts waiting to try to depoliticize the court in a sense? I don't think that makes much sense when it comes to the Second Amendment context, purely because of the timeline. So if the Supreme Court would have granted certain one of these cases, it would have been briefed over the summer and would have been set for argument at the start of next term or in the middle of next term, which would have been after the election. So it's not like the court would have weighed in on the Second Amendment issue prior to an election. So that doesn't really make sense to me, but some people have thought that maybe that's part of the reasoning. Now, when you're talking about state and local laws, I mean, obviously elections matter. And when you're talking about state protections and local protections of firearm rights, or, laws that infringe upon people's natural rights to self-defense, then you're talking about your local politicians or your state politicians. So obviously the elections will matter. I know that some people are asking specifically about, California protections and dealing with those. And as a former California resident, the part of the problem is, you live in a jurisdiction that doesn't respect the natural right to self-defense in that context. Now, when you're in those more progressive jurisdictions, there isn't a lot of hope at the end of the day. You have a Ninth Circuit that's actively, upheld regulations of firearm rights, has actively used a very low standard of review. They claim it's intermediate scrutiny, but it really just is rational basis with a new name. So you have a court that's willing to allow for firearm regulation, and you have a legislature that's willing to pass firearm regulation. So it's really difficult. And those are the states where the federal courts weighing in and getting federal protections matters most, is in those jurisdictions. So until the Supreme Court is willing to weigh in, it's going to be difficult for people living in those more progressive jurisdictions.
I guess that. Oh, go ahead. Sorry,
my
David.
advice, if you're in one of those really progressive jurisdictions, practice a lot with your revolver and your pump action shotgun.
And move maybe to another state. I think we're seeing that in California and some other states. Let's talk a little bit about one of the hot things right now is, in some circles, is taking police officers out of schools at a time where, especially here in Colorado, we've unfortunately had some tragedies occur here in the schools. So how does that play into this whole thing? We see this. Parents appear to want safer schools, and at the same time, we see a movement afoot to basically defund the police. And here in Denver, we've got a person on the school board here who they're going to take the police officers out of the Denver public schools. Is that a two-way case, or is that just something that has to be solved politically?
Yeah, that's a really interesting issue that has a lot of ramifications way outside of gun rights. So, for example, I was on a private school board after the Parkland shooting, and our local sheriff said, we will offer you for free at no cost a sheriff's deputy to serve as an SRO, a school resource officer. And we thought long and hard about it and ultimately said no, because one of the things that happens when you have a police officer in your school is that discipline often becomes a law enforcement matter. And so that's the really complicated thing. If you have two kids who get in a fight at the school, do you want the principal handling that, or do you want assault charges brought? It's not necessarily self-evident that it's better to get a 17-year-old or a 16-year-old or a 15-year-old into the criminal justice system versus dealing with those issues the way they were dealt with when I was in public school in Kentucky in the 1980s, which was you had a suspension. It was a matter for the principal. So these things are a lot more complicated than are we going to defend our schools or not defend our schools when you're talking about the presence of a police officer. And one of the things I think we need to combat actually is excessive alarmism over the school shooting issue. We're actually traumatizing kids with some of these drills we're running through, we're putting them through these, these lockdown drills, these simulated shootings, when it's still, thankfully, a very, 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 very rare occasion when you look at the sum total of schools in the United States of America. So this is not, these kinds of questions involve an awful lot of cross currents separate and apart from gun rights themselves.
Yeah, and on top of that, I mean, there's actually programs in some different states that allow, and certain school districts allow for teachers to concealed carry, pursuant to state law, but also pursuant to the school board's regulation. Here specifically in Colorado, we allow it. There's actually a program called FASTER. It's administered by one of our friends over at Independence Institute, Laura Carno, and they offer free training to teachers to deal with not only just conflict resolution, but how to respond if an incident did occur. And, that might not be the end all be all answer to everything, but the idea of having teachers that are used to conflict resolution, used to dealing with children, are used to the appropriate means of, dealing with an issue in their own school, having somebody that's also comfortable carrying and using a firearm, it could be a viable solution to that. And, it's been a good program here in Colorado, and it might have better effectiveness in other states as well.
We live in kind of crazy times, in case anyone has noticed, and there's, aside from the school safety issue, obviously there's some unrest among protesters or rioters, you want to call them. You see polls every once in a while, and I know you always have to take polls, public opinion polls, with a grain of salt, depending on how they're structured and written and so on. But do you think all these problems are turning public opinion generally against the Second Amendment? And are people afraid of it? Are people ready to change the Constitution in pursuit of safety?
Yeah, that's a great question. I don't think we know the answer to that. I mean, polling on Second Amendment issues is really pretty tricky and can often be misleading. Because one of the things that you'll find is you'll constantly see the media say things like, well, this gun control measure is incredibly popular. Why can't it become law? And yet the politicians who support those gun control measures consistently lose. So if it's incredibly popular, why is it the politicians that support those measures tend to lose? Well, the answer is, when you're talking about in the polls that really matter, at the ballot box, gun rights activists tend to be, and gun rights supporters tend to be more focused. Let me put it this way. If you have 100 voters, and let's say 80 of them express some sort of passive or mild agreement with a gun control provision, of the 80 who do, maybe only 15 are really intense about it, who really make that a priority in their voting. Whereas, like, say, all 20 who disagree with that gun rights position or that gun control position are very, very intense about it. So there's the difference between raw numbers broadly and the numbers who will get out and vote. And so this is one reason why the conservative movement has tended to be more successful in placing gun rights as a priority, as also judicial nominations as a priority, because people on the right, as a general rule, prioritize judges and prioritize gun rights more than people on the left prioritize those things. So it's not to say that people on the left don't want judges that reflect their values. It's just a lower intensity issue. And so people tend to come out for the things that they care the most about. And so that's why gun rights has long kind of punched above its weight in these raw numbers, because gun rights supporters are very, very motivated. And that motivation isn't reflected in broad public opinion polls, if that makes sense. And in fact, that motivation really began to grow a lot in the aftermath, during the Clinton years, in the aftermath of the assault weapons ban. A lot of people, the federal assault weapons ban, a lot of people say, well, that was the beginning of the end of what was thought to be sort of a Clinton revolution. This was sort of the beginning of the end of this remaking of American politics, and in many ways responsible for the rise of sort of the congressional GOP, which had been kind of a non-entity for a long time. And so one thing about gun rights supporters is they highly prioritize that issue. I do think there are an increasing number of gun rights opponents who highly prioritize. But that is much more event contingent. It ebbs and flows on the basis of dramatic events, public events, which is one of the reasons why I have long maintained that one of the best ways to secure long-term support for gun rights is to find creative ways to end the scourge of mass shootings. Mass shootings are, they're shocking and horrific on every level, and they shock and horrify the body politic. And so ending mass shootings and the gun rights community putting its intellectual firepower into ending mass shootings is, I think, a critically important on every level.
Another question from Zachary here. Are there any cases under consideration before the Supreme Court with tangential implications for other constitutional rights that are connected to second, like the right to due process? Are there any things there that also impact the right to due process that we have?
The only tangential case I'm aware of would be Rodriguez versus City of San Jose. That's a case that deals with a husband and wife. California has a mental health code and section and policy. It's called the 5250. Nope, 5150. And there was a case in which her husband was taken under a 5150 hold, which is a mental health hold. And she had a number of firearms stored in a safe. Under California law, they were possessed and owned properly by both of them. Police officers had maintained they had to seize the firearms, which is not actually pursuant to California state law. Long story short, they took them. She tried to get them back, and the city is refusing to return the firearms to her, even though, again, pursuant to California law, she's attested that she'll keep them in the safe, locked, won't give him the combination to the safe, and so on and so forth. I think that's the only Second Amendment tangential case I'm aware of. That would be a due process concern, because she hasn't been given her due process rights in that's the seizure of those firearms, because they were seized from him, and she was not able to adequately advocate for her own rights and wasn't given the process necessary to do so. So I think that would be the only one before the Supreme Court. There's a number of Second Amendment cases before the circuit courts across the country dealing with both square, straight Second Amendment challenges, as well as dealing with some more tangential ones. Mountain States Legal Foundation, we have a case that was just before the 10th Circuit addressing whether or not a lower court can abstain to hear a case based on a potential state issue when the case is dealing with the chilling effect on the exercise of fundamental right, dealing with the Second Amendment. And that's our Caldera versus City of Boulder litigation. So there are some cases that will be coming up dealing with some pseudo Second Amendment issues and squared Second Amendment issues, but I think those are all still kind of making their way through the pipeline.
But there do seem to be a lot of issues connecting Second Amendment with due process. I'm thinking here in Colorado, we have a red flag law that was passed. I think in New Mexico, they're looking at a red flag law. Could you explain to people what the issue is regarding red flag laws and how that is likely to pan out in terms of legal deliberations going forward?
Yeah, there are many different ways to draft a red flag law. And so there are a lot of different red flag laws out there. The general due process issue is that it has two key elements: notice and an opportunity to be heard. Okay. Now, one of the things about if you don't have both of those, and you're having a deprivation of a legally protected interest, which a gun ownership is, you're going to have a constitutional problem. One of the malleable things and one of the open questions in any given instance is, when does the process apply? So notice an opportunity heard. Is it always pre-deprivation? In other words, do you always have a right to an opportunity to be heard before the deprivation of the liberty? Are there circumstances where you do not have a right to pre-deprivation hearing? It's a post-deprivation hearing. And the law generally, let's put aside gun rights for a moment, has set up a number of circumstances in which your opportunity to be heard sometimes is post-deprivation. There can be such things as ex parte temporary restraining orders. There are orders, emergency protective orders that are in family law, for example, where someone has an order handed down and then they can go in and challenge it. And so this is a really complicated area. And I think the one thing I can say with a pretty high degree of confidence is that any red flag law that doesn't give you, at the very least, a very prompt post-deprivation process is going to have real constitutional problems. Another thing that's going to give you real constitutional problems is if you're going to have an indefinite seizure, or a seizure that is so long that it sort of functions as indefinite. So the better the red flag law from a constitutional standpoint, not putting aside public policy, is going to have defined periods of time for the seizure, and either preferably pre-deprivation hearing, but if there's an emergency where there's a post-deprivation hearing, it has to happen very quickly. Now, that's putting aside the public policy issue. The constitutional issue, though, I think that's where you're going to get into a lot of the due process arguments.
The other
You
side,
see a lot. Oh, go ahead. Sorry, Cody.
yeah, is standard of review. So the other part considered that they'll look at in due process is the lower standard of review when you're talking about a fundamental right, according to the Supreme Court, is going to cause problems potentially too. So states that have lower standards of review are more likely to be set up for constitutional challenges. But the key to remember with this is everybody hates when attorneys talk about standing, but red flag laws are the reason why you don't see a lot of these challenges going up in court is because they're coming up on a person by person, case by case basis. Because once a person has a red flag sought against them, then they have a potential injury according to Article 3 of the Constitution. So you can't just necessarily walk into a court and file a lawsuit and say the red flag law is unconstitutional unless you have been particularly harmed by it. So the way that these laws are structured, in addition to kind of some of the I might call them minor protections that have been put in place, again weighs into the consideration and will change how they inevitably get framed before any court.
Keith has a question that you guys can tackle. Where is Duncan versus Becerra? That's before Judge Roger Benitez in California. It's been over a year since Benitez ruled against the state on their magazine requirements. So where are we on that case?
I believe that case is briefing on the merits before the district court. So the ruling that Judge Benitez issued was on a preliminary injunction and enjoined California from enforcing its regulation for a week. People in California know this as Freedom Week, and they were able to magazines of any size. After about a week, the Ninth Circuit overturned Judge Benitez's ruling on the preliminary injunction. I believe that is currently now on the merits, meaning that they will get an authoritative decision out of the court. But I could also potentially be mixing that up with Rupp v. Becerra, and there's a number of other cases in California, which has been very busy with its litigation. But they have done, a lot of work drawing issues to the outfits that are doing litigation in California have done a lot of good work drawing focus to a lot of the issues that are occurring there.
You know,
I
these.
don't want to harp on. Oh, go ahead. Sorry, David.
I was just going to say these long and winding cases remind me of the old lawyer's joke that the great thing about America is that everyone gets their decade in court.
Anyway, I don't want to harp on the unrest issue, but I see a lot of news stories all the time about gun sales are up. You see more women buying guns. You see, and a lot of these purchases are being done by people who it might be their first time gun purchase. So is this helping in a kind of sad, perverse way settle the argument of why we have a Second Amendment, why we might need one? I mean, and in general, do you see things moving in the direction of a stronger Second Amendment support among the public, or weaker going forward? Let's just leave it at, let's just sum up that way, and then we'll sign off. And
can I say stronger and weaker? So here's what I mean.
Yes.
Our country is getting ridiculously negatively polarized, and it's sorting big time by ideology. So blue gets bluer, red gets redder as a general matter, except for, you know, so there are the swing states, right? They're the ones that are drifting one way or the other. But as a general matter, blue is getting bluer, red is getting redder. The number of states that are so-called trifecta states, which is where there's a governor, upper house and lower house of the same party, is at an all-time high. I think there's exactly one legislature in the entire United States of America that is split, with one house Republican and one house Democrat. That's how polarized we're getting. And so what that means as a practical matter is that at the state level, you just get more. You get more blue, you get more red. And so, you know, Tennessee, where I am, where we have supermajority GOP governance, I mean, you name the conservative legislative initiative, and it's either going to pass or get serious consideration, and gun rights are no exception. I mean, I would be very, very surprised if constitutional carry doesn't pass. And likewise, I would be very surprised if in California there weren't additional gun restrictions. And so that's why, you know, with a lot of things, my answer is, are we going to be more this or more that? And my answer is yes, depending on where you live.
And I think on that, and I think so we have seen a lot of spikes in gun sales. A lot of those are likely gun owners who are going and buying a new gun. I know of a couple friends that have used it as an excuse to justify to the significant other that we need another firearm in the house. So I'm sure there's a lot of that, a lot of bargaining going on. What I think it might do, and I'm not sure, but kind of what David's talking about, as guns only drive certain people to the polls, whether it's for or against. I think what you might get is fewer people driven to the polls against guns. And possibly because there are, we all have anecdotal evidence from friends that own shops or run retailers that there's more people coming in that are first-time buyers, and there's a lot of women. So what you might get is you might get fewer of those women that are necessarily motivated by kind of the anti-gun rhetoric. And, you know, I think that might be something moving forward. But I think the key here is to focusing as this is a movement. This isn't just, you know, one person advocating for or against. This isn't one politician. You know, there's been a really strong movement in legislatures for the past 20 years dealing with this. And what you're seeing now is you're seeing a really strong movement in the courts. And you're seeing, so Mountain States Legal Foundation, we teamed up with NRA, Firearms Policy Coalition, and Second Amendment Foundation on our lawsuit in New Mexico over the gun store closure. I think that's the first time ever that you've seen all of those organizations on a lawsuit fighting the battle. So in that vein, what Mountain States is doing is we're going to be founding our Center to Keep and Bear Arms. And our goal there for that center is to have a concerted push for litigation in those areas, in keeping, in bearing, and in defining arms. And our goal is that by setting up concerted litigation across the West, but across the country, that we can frame these issues in such a way that, you know, we'll put them before circuits and have consistency. And where there are circuit splits, we can work with the other organizations. We've developed great relationships with them in order to get those splits in front of the Supreme Court. So I think the legal movement, you know, I was a little bit depressed last week, maybe, and, you know, you take it with your lumps. But I think the legal movement is in a particular place to work together so well to advance this issue. And Mountain States fully intends to do that.
Maybe we should leave it on that optimistic note. I want to thank our participants today, David French, obviously, and Cody Wisniewski, and also everyone who offered good questions today. We really appreciate those. You can learn more about this and other cases online by visiting our website, mslegal.org. That's mslegal.org. We're also on Twitter and Facebook, so please friend and follow us when you can. Again, I'm Sean Page, Communications Director for Mountain States Legal Foundation, and I want to thank you for joining us and tuning in today. We hope you'll join us for our next Mountain States Legal Foundation webinar. Thanks for your time today.